Good morning and welcome to this webinar by Dickinson. I hope you can see and hear me clearly. There will just be hopefully a little flurry of people continuing to join over the next couple of minutes. I hope that's not too disruptive for you. Thank you to everyone who has been able to join us this morning, particularly those who are juggling childcare with I know schools affected today. So particularly appreciate it's not always easy to join these events, and pleased to see you here this morning. My name is Ben Troke. I'm a partner in the healthcare and public law team at Hill Dickinson. I'm based in Leeds, but I've always worked with clients all over the country. Paul Alliston and Joanna Crichton are joining me, and will introduce themselves as they come to their sections of the presentation. This is the third of 4 webinars that we have done on a range of topics. The final one is on employment and HR issues and is on the 21st of March. And you can still sign up for that. And there are recordings of the other sessions that have already been done available on our website. Excuse me. I'm just going to cover bits of housekeeping before I set out what we're going to talk about today. So please note that your microphones are muted and your cameras are automatically switched off. There will be a point hopefully later in the session where we will enable cameras and microphones, and you can jump in and make the Q&A a little bit more interactive than just sticking stuff in a text box. And I think the numbers are going to allow that to be feasible. If you are having problems with the sound, God help me, try logging off and logging on again. Check your device settings and make sure you've disconnected any other bits of kit that might be causing trouble. This session is being recorded, but what we're going to suggest is that we turn the recording off once we finish the substantive presentations, and hopefully we'll still have 10-15 minutes left for questions at the end, and then we can have a bit more free discussion without the Q&A being recorded, because that can sometimes be a little inhibiting. If you want to tee us up rather than catch us out with your questions for the Q&A, do please put them in the chat box, and we'll keep an eye on those as we go through the session. And please do fill out the feedback form that you'll get at the end, which is really, really helpful for us, making sure that we do these events in a way that is actually helpful for you rather than what we think is helpful for you. So tell us what you'd like to hear from us in other sessions. Thank you. The session for today. The third of the 4 sessions that we're doing. The focus on this one is on the issues that we deal with and the work we do in what we call the healthcare and public law team, where myself, Paul and Joanna work. One big chunk of that team's work is dealing with inquests. I appreciate that's not such a big issue for ICB clients, although we are seeing more and more ICB client inquests. The other big chunks of the work that we do in healthcare and public law are about the decision making about the provision of care, and that can be what we've called complex commissioning for shorthand. It can be disputes about continuing healthcare, about Section 117 funding, about what people are entitled to and who's going to pay, essentially. And then you've got all the responsibilities that come from that in terms of taking cases to the Court of Protection and dealing with issues that arise relating to deprivation of liberty. So those are the 3 chunks of the presentation for today. And I'm going to start off by talking about complex commissioning as a kind of generic issue. To manage your expectations, Paul and Joanna are likely to be a little bit more helpful than I am in their more tangible bits, getting towards some helpful guidance or some advice. As I put my slides together, I start to feel like I've just basically got a long list of things that are difficult, that are things we routinely deal with, but there are no easy answers, certainly not in the 10-15 minutes or so that I've got, and managing expectations is important. But I hope it's helpful to give a bit of an overview of some of the issues where we've do routinely advise ICB clients, and perhaps have a think about why we see these issues so often, why they cause trouble, and maybe that would be helpful for people who are newer in role. People who've been there, done that, know the answers, can help us out in the Q&A towards the end, please. But we are also conscious that ICBs themselves are new organisations and finding their feet. Just a line to introduce myself. I've been dealing with health and social care legal issues for getting on for 25 years, always acting for commissioners and for providers all over the country. It strikes me, as I sort of reflected on this, trying to put together some slides, common causes of things that cause trouble are managing expectations, whether that's expectations of ourselves or the expectations of patients and families, but also the fragmentation that's inherent in the system. So I'm going to talk a little bit about that fragmentation and some of the boundaries, some of the borders it throws up, and therefore some of the disputes it inevitably generates. And it struck me that essentially our role as ICBs and as advisors to ICBs is about drawing lines. It's about finding the edges of our responsibilities. One of the boundaries is health versus social care, which is which. How do we draw that line? One question is must we commission particular care? Will we commission it? By that I mean us, as opposed to another bit of the NHS. And what do we have to pay? How do we go about the commissioning process? What do we pay? So you've got a list of people who you will routinely have boundaries and therefore friction with. That's ICBs and local authorities, that's ICBs and patients and families, that's ICBs and providers, and that's ICBs and other ICBs when it comes to who pays for what. I'll start with that boundary between health and social care and why that's tricky and why it always will be. I think a big picture helps with this. At least it gives me some comfort. If it doesn't give me the answers, it comforts me to know why it's a difficult question and why it's always going to be a difficult question for everybody. If you go back to a definition of health, the World Health Organization definition of health is a state of complete physical, mental, and social well-being, not merely the absence of disease or infirmity. It's really quite hard to define health and define social care in a way that draws a clear, bright line, and that's always been the case. And this is a cartoon I like. I often use this when I'm giving training on the division between health and social care. If you go back to the founding of the NHS, you look at the Beveridge report in 1942. This cartoon, published at the time, captures his conceptualization. The sort of founding platform of the welfare state was tackling 5 giants: want, ignorance, disease, squalor, and idleness. When the welfare state as we know it was built after the Second World War, we had the Education Acts tackling ignorance, we had slum clearances tackling squalor, we had the foundation of the NHS Act 1946 tackling disease, we had the National Assistance Act 1948 tackling want. But disease and want were conceptualized separately, differently, and the structures for the social care system and the healthcare system went off down these separate lines from that point onwards. Social care demand is managed largely by thresholds and limiting access. In healthcare, it's usually managed by waiting lists. But the crucial distinction for these purposes is that social care was often means tested and paid for, and healthcare was free of charge, although quite quickly bits like prescription charges were taken out of that. So immediately we created a distinction that was artificial. Nye Bevan, founder of the NHS himself, was the Minister of State for Health and Housing because of the inextricable link between all these issues. But we set off down a path of having health and social care treated differently, and crucially, because one is means tested and the other one's free at the point of delivery, it makes a massive difference to the patient, to the family, which side of the line that is. But the line is essentially arbitrary, artificial, And no wonder we have enormous disputes about it. It's inevitable because of the way the structure is set up. So one place that line has to be drawn is in terms of continuing healthcare. Bearing in mind what I've said about the sort of the blurry line between health and social care, this is how we try to define it for the legal framework that we've got at the moment. Continuing healthcare, so a package of health and social care that is fully funded by the NHS because somebody has, having got through a checklist and then a decision support tool, has a primary health need, whatever we mean by that. Which is assessed by reference to the nature, intensity, complexity, unpredictability of various needs across a range of domains, which are scored on a chart, and you tick in this box, and ultimately you end up with someone who is or isn't eligible for continuing healthcare. Decided by an MDT, but ultimately the ICB's decision, and there's some useful case law on that, case of Gossip, in which Hill Dickinson acted for the CCG as it was at the time. But no wonder we see arguments between patients and families and the NHS. No wonder we see arguments between the NHS and local authorities about how we assess entitlement for continuing healthcare. If you look down the other end of the telescope, the Care Act 2014, which codified all the social care legislation, does put limits on what the local authority can provide. And you quite often get the local authority say, well, we can't do this. It's health services, it's beyond our powers. The only thing explicitly local authorities can't provide is services by a registered nurse, hence the funded nursing care element where that's required. But then you get this really circular definition that they can't provide health services unless doing so would be incidental or ancillary to doing something else that the local authority is doing. And it's the kind of thing that a local authority can be expected to provide, which is entirely circular definition. It doesn't help us much. So these things don't do us any favours really in drawing that line, but it has to be drawn. The guidance we get comes from the National Framework on Continuing Healthcare. The most recent version of that was July 2022, which didn't really change the goalposts enormously, but it did cause a load of confusion about the question of consent for the CHC assessment process. And happy to pick up any questions about that. Joe and I both spoke at an event for another organisation about the confusion caused as a result of the framework suggesting consent needed to be tackled a little bit differently in the CHC context. Moving on to other streams of funding that cause problems. It's not all about continuing healthcare. Section 117 of the Mental Health Act, aftercare funding causes enormous problems. Aftercare means meeting a need arising from a person's mental disorder and reducing the risk of deterioration and further admission. Crucially, it is non-means tested. It's a joint package of care to be funded by the local authority and the relevant ICB. In what proportion? Nobody knows. There's no guidance whatsoever, and you just have to sort it out through a bun fight between yourselves and the local authority. Also, although places have different arrangements, but that doesn't help. What does it include? Doesn't help. A bit vague. There is some case law about whether or not it should extend to include accommodation or not. Again, it's a bit woolly. When does it end? We have had a useful Court of Appeal judgment, I think it's the end of 2021, the Worcestershire judgment, which talks about the need to explicitly draw Section 117 entitlement to an end in order to stop it running. I think that's right, and something I hear from a lot of ICB clients is that there is a very significant expenditure on Section 117 funded cases that don't have that rigorous review about whether they're still warranted or actually the need for Section 117 care has come to an end. I'll get on to the mess around who is responsible for paying for Section 117 care in terms of responsible commissioner and who pays in just a second. Just before I do, a couple of other funding streams that also throw up questions: joint packages between the local authority and the ICB, and the shares they need to be paid in, and who takes responsibility for the case management decisions, who takes responsibility for taking stuff to the court of protection in those situations where it's ambiguous. Individual funding requests where people want a particular kind of package or treatment to be provided, and I should have added top-up funding, where people have a certain core NHS package and they want to be able to add to it themselves. And the rules around that have been complicated and come and gone over the years. I mentioned who pays for stuff, and that's another minefield. It's another area where we give a lot of advice. So we've got the legislation. I'll get to an extract of that in a minute. You've then got some regulations called the standing rules. You've then got some regulations called ICB responsibilities. You've then got some more regulations called exceptions to ICB responsibilities. And honestly, sometimes pick your way through that and find out who is the responsible commissioner. You do need a damp towel in a dark room and plenty of time, and it doesn't make it easy for people to coordinate or collaborate or to make plans. One of my frustrations in this field, of course, is that we're talking fundamentally about different pockets of the same trousers, and the time and money that is spent arguing about which bit of the NHS is going to pay for something can be really frustrating. But I get that everyone's got their own budget, their own responsibility, their own statutory responsibility, and we are structurally set up to have these disputes, though they are a shame. And overlaying all of those regulations, you've got the who pays guidance. Now, an earlier version was less than helpful because there are aspects of it that were difficult to square with the legal framework, and it caused confusion, particularly when it was amended in 2016 to change the rules specifically about Section 117 funding, which caused even more chaos. There was a substantial rewrite in August 2020, and then it was updated again in June 2022, largely to make provisions for the creation of ICBs. It is now much closer to the simple starting point that pretty much everything follows GP registration, which is better than it was. And there is a dispute resolution process now in place since August 2020. And you are very, very much discouraged from going off to get separate legal advice about any of those issues. But sometimes you might need to, and it's something we routinely deal with. What do we pay? Just to rattle through these last couple of points. A question for ICBs will always be, do we set limits on the cost of placements we are prepared to pay for? If we set limits, how do we set exceptions? How do we make sure they are fair? How do we make allowances for protected characteristics in the Equality Act and reasonable adjustments? Does this play out, for example, in saying residential care must be the package provided because the dom care package that would be the equivalent is too expensive, for example? And how do we reflect patient choice and rights in that framework? How do we set the cost of individual CHC placements? And that's a particular issue now that we've had CCG footprints merged into a bigger ICB, where individual CCGs had a different approach. And now the ICB as a whole is being challenged that it must, they are told, adopt the approach of the most generous of the individual CCGs in order to establish consistency. You need to be really careful about that pressure to, I never thought I would use this phrase with a straight face, level up. It doesn't necessarily follow that every bit of the ICB has got to be as generous as the most generous CCG was, which is now part of its footprint, because there may have been other things that CCG didn't fund in quite the same way. That's the reality of local resource allocation. Is, the less generous way to put that is postcode lottery. There are ups and downs to what resources are allocated and how those decisions are made. The advice is always focus on the decision making in public law principled terms. Focus on how you make the decision what to fund. I'll say a word about that in a second. Almost always you can say no if you say no in the right way. Okay. And rationing. We don't like the word rationing. Let's say resource allocation for a euphemism, but rationing is an inherent part of the system, and it is now the ICB's part of the system. Have a look at this. Back in the day, the bottom bullet point the NHS Act 2006 said the Secretary of State must provide throughout England, so everywhere, to such extent as he considers necessary to meet all the reasonable requirements, ... And then there's a list of hospitals, doctors, nurses, ambulances, so on, the stuff that the NHS has to provide. That was changed in 2013 for CCGs and changed again now for ICBs. An integrated care board, not the Secretary of State, must arrange the provision to such extent as it considers necessary. You've got the job of deciding what is or isn't necessary to meet, note it says the reasonable requirements. The all in the all reasonable requirements has also gone, but read into that what you like. My last slide, just about this point about rationing or resource allocation. The courts have always been very sympathetic to public bodies necessarily making difficult decisions about the allocation of resources. I could pick any number of cases as an example, but one struck me because I was studying medical law at university at the time. Jamie Bowen and Cambridge Area Health Authority. She was a 10-year-old girl with a rare form of leukemia who'd had one cycle of treatment which hadn't worked. She had a cycle of different treatment which hadn't worked. And there was a third treatment. Very, very small chance of success, very, very expensive. And the health authority said, no, we won't fund it. And it was challenged through the courts. And the High Court said, this is a 10-year-old girl's life and death. You've got to do more than toll the bell of tight resources. And it went up to the Court of Appeal, and the Court of Appeal said, no, that's not right. This is a public body with a public role and difficult decisions to make. It can't be brought into court with the accounts to justify what they're paying for instead of this. That's their job. Okay, and they'd like to pay for all kinds of everything, but they can't. That's just the reality. Okay, and so there is good Court of Appeal authority, good authority in all courts of case law, that it's okay to say no as long as you say no in the right way. Pamela Coughlin, one of the founding cases of the continuing healthcare body of law, is a case in which she was moved from one placement to another. And the reason that was held unlawful was because the health authority was breaking its promise that she would have a home for life. So you need to focus on the decision making. Say no, but say no in the right way. That means acting within your powers, taking into account what you should, not what you shouldn't. Obviously not being biased, not being prejudiced, being reasonable. But being unreasonable is a really high bar. So unreasonable that no reasonable decision maker could reasonably have made that decision. It's a really high bar to be unreasonable. Following any process you have set, if you've said you'll do it a particular way, do it that way. More often than not, if decisions are successfully challenged, it's because of that process failure, and in particular not keeping to the way we said we would do things. Last word on this before I hand over to Paul is resource allocation is not a matter of best interests. As the philosopher Jagger says, you can't always get what you want. And that does play out in the context of the call to protection and arguments about best interests decision making, which is where I'm going to hand on to Paul. Thank you.
Thank you, Ben. Hi, everyone. I'm Paul Alliston. I'm a partner in our Manchester Health Care and Public Law team, and I lead on the court protection work in that team. And it's that subject that I'm going to talk about this morning. Just bear with me. An up-to-date look at how complex commissioning interacts with the court protection and how that might change even subtly as a consequence of the developing ICB structures and governance. So the ICB, by way of its commissioning responsibility owed to individuals with complex needs, will, just as the CCG predecessors, invariably lead to involvement with the COP. Now, largely the way in which the CCGs were involved in COP proceedings is now replicated for ICBs, although that could potentially change significantly in respect of commissioned care constituting a deprivation of liberty, which Joanna will speak about shortly. So while the contact with the COP ostensibly remains static, replacing the party name from CCG to ICB, as the decision-making and responsibility for that is scaled up and it's centralised, within the ICB, it's going to be important to keep focus on the COP cases, particularly about individual patient care. It's also going to be important to keep tabs on these cases in terms of highlighting MCA compliant decision making, which obviously permeates through as a duty of an ICB in performing its complex commissioning role. So as you can see from the slide, that shows where, in my experience, the ICB and the COP will meet frequently. At the risk of overgeneralization, individuals with complex commissioning needs are likely to fall into not only the jurisdiction of the MCA via incapacity, but also going to require difficult decisions regarding their health and welfare to be made. Now, I said earlier, Joanna's going to be dealing with DOLS and DOLIC, which is an acronym I've come across very recently, but I like it. And Section 21A, so I won't talk about that, but what is left for me to talk about outside that sort of critical mass of DOL-related COP applications is applications relating to welfare, so beyond disputes concerning deprivation of liberty, so medical treatment and safeguarding issues. And an example of this comes in the guise of the thorny issue of COVID vaccination. So, as you'll no doubt appreciate, the arrival of the COVID vaccine brought with it a stratification of priority aligned to the risks of contracting the disease for cohorts of individuals in the population. Now, again, at the risk of overgeneralization, those with complex needs were or are considered at higher risk, and if they're incapacitated from making the decision themselves, then a best interest decision-making process should be undertaken to determine whether the vaccine should be administered. Now, for those individuals known to the CCGs at the time, due to their care being funded by CHC or 117, for example, the commissioners would or should have been cited as to the need to make a best interest decision about this and resolve any dispute by way of a COP application. Now, they would or should have considered whether the vaccination would be resisted by P, and if so, what restraint would have been necessitated as a result. Now, this might also require an application to the COP. Now, where things became slightly more opaque, however, was the cohort of vulnerable individuals, the LDA and dementia cohort, that weren't known or directly funded by the CCGs. Now, these individuals would, in my experience, come to the attention of an individual CCG via a safeguarding route. And because it was a health-orientated decision, driven partially by the GP, it's landed with the CCGs. Now, the GPs weren't or aren't really used to sitting in that decision maker capacity, and they were, or certainly aren't, generally geared up to either recognise the need to bring the matter before the COP or to make the application itself. It was further compounded by the vaccine rollout, effectively bypassing many of the conventional NHS structures, and the initial uncertainty as to which organisation or authority or person had the responsibility to make any application, it still hasn't been cleared up by the courts. Now, when we were first approached to advise on this, it was clear that ultimately it was a matter that had to be resolved, and it was a matter that had to be resolved urgently. It was a health decision, so I think you rule out the local authority. And at first blush, it's driven by P's GP. GP being part of the CCG GP member organisation, and therefore you could feasibly substitute the CCG into the role as applicant in a court of protection application. It also, at the time, tied into the CCG's role in terms of the vaccine rollout regarding ensuring the administration of the vaccine into the population that it served. So the CCGs brought these cases, and a raft of case law was created in a relatively short space of time on them, and some accepted principles can be taken away from that case law. But Over the last 12 months or so, as you'll have experienced, no doubt, there's been a shift in the approach to the disease and by extension, the vaccination programme. So we arrive at the present day. There remain people in these vulnerable cohorts with whom an ICB has no direct relationship. There will remain steadfast objection to the vaccine by some people, perhaps more so given recent events and news that may be preventing people in this vulnerable cohort from accessing the vaccine. But there is a subtle difference between pre-July of last year and now, and that is that the ICB isn't a GP member organisation. So there is a distancing between the coalface, as it were, and an organisation that ostensibly is to bring the application. Now, whether this would play out to replace the ICB as the appropriate last resort organisation is still, in my opinion, unclear. Fundamentally, the court's always viewed any delay arising out of dithering as to which authority ought to bring one of these cases very dimly. There's also very little sympathy to be gained even from the delay preceding an ICB being notified of the issue or the inevitable lag in obtaining the evidence necessary to bring the matter before the court, as our team found out in the DC case. I think presently the advice as per the Green Book, Chapter 14A, which you can see on the slide, is unchanged as to the clinical benefits relevant to this cohort of the vaccine. So when notice lands that a decision as to an incapacitated vulnerable person's access to the vaccine or a booster is, for whatever reason, being delayed or prevented by a dispute, then the courts are going to want to expeditiously resolve it in P's best interest one way or another. And I think that for now, and I think, and we maybe pick this up in the Q&A, that Ben might disagree with this, but for now, the ICB, in my opinion, still occupies that same last resort position as the predecessor CCG. It may be that a test case is run whereby it's argued by an ICB that a GP practice should properly bring the application. And I suppose if that doesn't amount to any delay, it may be given some airtime by the court. But until then, I think we are where we were. So this remains an issue that isn't going to go away unless the guidance of the UK Health Security Agency or the Green Book removes or alters the benefits that to date have been the core of these applications. These benefits have been by and large accepted by the courts, but nevertheless, these cases aren't to be treated as a formality insofar as best interest decision making is concerned, particularly in favour of the vaccine. The SD case confirmed that there can't be any blanket policy or decision regarding any particular cohort. And furthermore, any best interest decision should adhere to the principles of the Act in terms of being time specific. So the courts are highly unlikely to approve annual boosters in advance, for example. These cases are invariably going to be contentious. There's a huge array of reasons that will and can and have been presented by those who object to their family member receiving the vaccine. The case law has dismissed arguments regarding efficacy and even one case, the vaccine being suggested to be un-Islamic. Mr. Justice Poole, in the E case from March of last year, suggested that it isn't the role of the court to arbitrate medical controversy or to provide a forum for ventilating speculative theories. The court's there to evaluate P's situation in the light of authorised peer-reviewed research and public health guidelines and not to carry out a review of them. So despite this, the more exotic of objection, shall we say, will be hard to dissociate from the nature of this particular dispute, particularly given the conviction which some hold against the vaccine. What has to be focused on is a clear link between this or any other objection as viewed from P's perspective, rather than a view held by their family. We're concerned with what's in P's best interests. There isn't an auto-alignment of likely wishes between P and their family, and evidence is going to be required to substantiate this. The decision is also not a clear case of substituted judgment when P's likely wishes and feelings against the vaccine can be ascertained. For instance, if objection is clear from likely wishes and feelings, it can and has been overridden. But an objection that does hold significant weight is the likelihood of resistance to the administration of the vaccine and the plan devised to restrain, whether physically or chemically, to facilitate it. Not in all cases, but as Mr. Justice Hayden suggested, it is a strong pointer to that not being in P's best interest. So, food for thought, no doubt with this. Take-homes are that despite the world feeling very different to 2 years ago, this issue hasn't gone away. And in my opinion, it's going to be hard for an ICB to decline to do what its predecessor CCG did in terms of going to the COP, for now at least. We've been involved in a lot of these cases, and obviously we can assist in bringing them, but also advising as to how to manage it going forwards in your ICB. I suppose we might touch upon that briefly in the Q&A later. So, moving away from the vaccine cases, and actually away from the COP momentarily, I was instructed in this case last year, JJ versus Spectrum. Still am, as it's going to be heard in the Court of Appeal this year. The case relates to a prisoner who is so profoundly disabled that he needs to be fed by a care team employed by Spectrum, and wanted to be given foods of his choice, despite them causing significant risk of choking and death. Spectrum refused to offer him the foods that they felt riskiest, which he argued was unlawful, and remains on hunger strike as a result, a hunger strike of a fashion, because it's gone on for a very long time, but nevertheless, and there we are. So he had, in this case, in these circumstances, this guy has full capacity. So we're not in best interests territory. But the judge in the judicial review held that it was lawful for the carers to make reasonable risk-based decisions about what food they're willing to offer. Now, I suppose, whilst this case isn't a court of protection case, it is nevertheless important to re-emphasise the importance of, you can only make a best interest decision out of available options. And I draw your attention to it because it also covers an issue that we come across quite a lot with people in care packages who have capacity to make decisions, but are requiring or suggesting that exercise of autonomy requires others, care providers, to do things or expose them to things that aren't clinically safe or appropriate. So I suppose take home is the available options point, but also that autonomy has its limits. I can see that we are slightly running against the clock, so I'll be quick in terms of next case. Another case I'm involved with in the Court of Appeal, or was in the Court of Appeal. I include it here not to just big up my cases, but to touch on a very important development as a result of the case, which is that if you are, or an ICB is commissioning in the face of extreme opposition from P's family, then the ICB in this case took an extraordinary step of injuncting the family. So I won't go into the background of the case, but in short, it related to a very delayed discharge over years, and the court eventually determined that a placement in the community was in P's best interest, and that was effectively, post that declaration in the court, sabotaged by the family by whatever means they could find to try and get the provider to withdraw the placement. There was only one placement available, taking an awful lot of time to arrange. So the ICB in that case took the step of injuncting the family from their behaviour, from what they were doing to sabotage the placement, to preserve the placement. And the Court of Protection in the first instance did injunct the family, and that was, aside from a procedural point, upheld in the Court of Appeal. So take home, if it's necessary to preserve or protect something or somewhere considered to be in P's best interest, then the COP can take this step. So the ICB does have an enforcement angle. Last, just very briefly touching on the importance of getting the MCA right. I think Joanna will probably touch on this as well. But the CQC are focusing on reducing inequality in healthcare provision, and view getting the MCA wrong from a provider's perspective as a key component, or highlighting when this has got wrong as a key component in this drive. You'll see the fine handed out to the Birmingham Trust in October, the reason why, which is effectively non-compliant best interest decision making. As you know, ICBs have a duty to reduce health inequalities.
I don't know if I've frozen or Paul has. Joe, can you hear me?
I think Paul's frozen. Ben, I can hear you, but we've lost Paul.
Okay. All right. Well, in that case, let me just finish his point. Get the MCA right is very important to providers, commissioners, and the CQC. And with that, because he was running over anyway, but I promise I didn't pull his plug. Let's hand over to you, Joe. We're going to need to put the slides back up, aren't we?
Yeah.
I think Paul had done that.
Paul's crashed them.
Okay.
Can we ask Lorraine to get the slides back for us, and I will start without my slides, if that's okay. Oh,
let's see if we can, and I'll let Paul back in. Hi, Paul. I've taken the liberty of wrapping you up since I think you froze.
I wondered whether I'd been kicked out.
Just that. No, I promise. it wasn't the hook.
Sorry about that, everybody.
From the chair. I have taken the chance to hand on to Joanna, given the time. So, Joe, I'll let you crack on. Thanks, Paul.
Yep. Okie dokie. Morning, everyone. I'm Joanna Creighton, and I'm a legal director in the Liverpool team. I've been a healthcare lawyer for about 16 years now, and particularly specialising in NHS continuing healthcare and the Court of Protection Mental Capacity Act work that we've been talking about this morning. So I'm going to talk to you about specific legal responsibilities that arise for the ICB when we are talking about a deprivation of liberty that's occurring. And these generally arise when the ICB is commissioning a package of care for somebody, generally, for example, through CHC, but there are other funding streams as well where this arises, such as Section 117 aftercare. So I've just tried to do a deprivation of liberty in one slide. I think most people will be familiar with what is deprivation of liberty, but there might be some of you that are new to this area, and I just wanted to give you the grounding. Obviously, deprivation of liberty is a massive topic in itself, but we are rooted in human rights law when we're talking about what's deprivation of liberty, and it goes back to Article 5 of the Human Rights, the European Convention on Human Rights, rather. So no one shall be deprived of their liberty save in the following cases and in accordance with the procedure prescribed by law. And one of the list of cases where it's lawful to deprive someone of their liberty so long as the criteria are met, is in relation to the lawful detention of persons of unsound mind. And then the legislation goes on to say that anyone who's deprived of their liberty shall be entitled to take proceedings to challenge this speedily by a court. So what we have there is there needs to be a procedure prescribed by law. It has to be one of the recognised criteria cases when it's appropriate, and the individual who's being deprived of their liberty needs to have the ability to challenge it via a court. In terms of the procedure prescribed by law, in England and Wales, we have the Mental Health Act in cases where that's appropriate, the deprivation of liberty safeguards in some other cases where people are in hospital or care homes, but for all other cases, there needs to be an application made either to the Court of Protection or in some cases to the High Court where the Court of Protection hasn't got jurisdiction. So most people again will be familiar with Cheshire West, which the Supreme Court heard in 2014 that gave us the acid test to identify when a deprivation of liberty is occurring. It's when someone who lacks capacity is under continuous supervision and control and not free to leave. It's a very wide test in itself, and the individual elements by subsequent cases, continuous supervision and control and not free to leave, also being defined fairly widely, meaning that we have lots of people who are currently viewed as being deprived of their liberty, and the impact of Cheshire West was felt particularly for people in the community, in their own homes or in supported living, where previously we didn't think that that was a deprivation of liberty. It then was. So Section 21A applications, if you are in an ICB, you might be wondering what all of these court applications are that teams are having to deal with. And this goes back to the need for someone to have the right to challenge their detention speedily before a court. This is the mechanism by which someone can make that challenge if they are deprived of their liberty in a care home or a hospital setting. There are quite a lot of Section 21A cases at the moment, and there's a number of reasons for that, one of which is a backlog from the pandemic. They are generally brought by the relevant person's representative, which in a lot of cases is an independent IMCA, who weren't really able to do a lot of visits. Obviously, during the various lockdowns, they weren't going out into care homes in particular to see people. They're not able to. So we have a backlog of those cases. Individuals have an entitlement to free, non-means tested legal aid to bring these cases. And the cynic among us might think that it's an excellent funding stream source of work for the lawyers that carry out that type of work. But one of the main reasons there's so many of these cases is the impact of an objection from P. So the person being deprived of their liberty, known as P. There's case law which indicates that if there is an objection by P to their placement, then it should trigger an appeal to court. So we are talking about people who lack capacity. If they demonstrate an objection either by saying, I don't want to be here, I want to go home, or perhaps by their behaviour, if they're not capable of communicating that in any other way, then the representative for P is bound to bring an application to challenge this. So there are large numbers, as you can imagine. People are often objecting to their placements, whether or not the objection's reasonable. We're talking about protecting human rights here, so it's important that they have the right to challenge their detention. It doesn't matter whether or not that challenge is likely to be successful. So just to give you an example of the positive impact of Section 21A applications, I had a case I dealt with where an individual who was deaf had been in a particular care home for a number of years, and for various reasons the annual CHC reviews either hadn't taken place or hadn't particularly identified the needs surrounding his being deaf, and he couldn't really communicate with any of the carers at the care home because they didn't have those skills. And so a Section 21A application was brought, and it led to him moving to another placement which had specialist support, and they were able to communicate with him using British Sign Language. So you can see their massive positive impact on this gentleman's life. They're not always productive, and they can lead to frustrations with the professionals and the nurses. Like I said, it doesn't matter whether or not it's likely to be successful. The individual has got the right to bring it. So you do have cases where it's entirely obvious that P's in the right place, even though they're saying they want to go home, they clearly couldn't manage there. Or perhaps it's an elderly lady with dementia who says she wants to go home. What she means is she wants to go back to being 5, her childhood home with their mum and dad, and clearly nobody can achieve that for her. But even so, it's about the process, it's about protecting people's human rights and ensuring that they have the right to challenge this. So some guidance on how you might avoid these applications being brought, or perhaps minimise the impact of them if they are. Always be looking at his views and objections, whether they are in the appropriate placement. If they are objecting, can we look at an alternative environment, somewhere less restrictive? Considering the least restrictive option, can any specific restrictions be removed? These cases are not always about a move of placement, and it's sometimes about things like community access, family visits, even wanting to have more access to the internet or a mobile phone. So in reviews, can we identify restrictions that perhaps can be removed? Checking conditions on a deprivation of liberty authorisation is important. So if someone has a standard authorisation in a care home or hospital, there may be conditions that require the Commissioner to review something like community access, or look at whether they could go home with a package of care. And often the Section 21A application is brought because the Commissioner's not looked at that in a reasonable amount of time. So the conditions of a standard authorisation often give you a clue and a heads up really as to an issue coming along the line. Do you keep someone's care under review? The case that I mentioned is an example of that, where, you know, they weren't picking up that this gentleman's needs weren't being met in terms of his communication needs. If a case is brought, we need to be clear on the funding and case management responsibilities. Sometimes the ICB is brought in because it's joint funding with the local authority, but in actual fact, there's an arrangement with your local authority that they are the case manager in those cases. Sometimes you can manage to avoid being brought into the proceedings altogether, or if you are, have a kind of lesser role, not required to go to hearings, which will obviously reduce costs and management impact. So that's something to look at if and when you are brought into these proceedings. And that's certainly our approach when we represent our clients in Section 21A applications, is we're always looking to reduce the impact and ensure that you don't incur any unnecessary costs. Flagging at this point that under liberty protection safeguards, if and when they come in, individuals in their own home or supported living will also be able to bring a similar challenge to this. And that just takes us nicely onto liberty protection safeguards. I'm going to have to speak really fast. These are intended to be a sweeping change in our law to replace the deprivation of liberty safeguards entirely. They will have significant responsibilities that are new to ICBs, and the ICB would become a responsible body if it's commissioning someone's care mainly through the provision of continuing healthcare. So new duties under liberty protection safeguards would be ensuring that the 3 assessments take place or obtaining them from other sources, carrying out the necessary consultation with P's family, people interested in the care, and carrying out the 3 stages of the authorisation process within the ICB or externally if that's required. And then the final authorisation sits with the ICB. So a positive thing, this is going to reduce the need to go to court of protection for deprivation of liberty in the community. A negative thing, the ICB has got more responsibility sitting within itself, and there's also the 21 timescale to complete this process. I'm not going to go into LPS in any great detail, partly because of time, but partly because we're unclear at the moment when it's going to come in, and we are starting to wonder if it is going to come in at all. I've got to give photo credit to Ben here for the photograph on the slide. We've been told that there would be an announcement on the response to the consultation in the winter of 2022 and 2023, and clearly spring has now sprung, although that photo was taken, I think, before all of the snow. In terms of timing, the only real candidate for LPS coming in now is April 2024. The reasons for that is October this year is just simply too soon. October 2024, we're likely to be in the throes of a general election, so the political turmoil is likely to impact LPS. So if it does go ahead, then there will be, as I say, the new responsibilities for the ICBs and the challenges of implementation. If it doesn't, we are left with the same problems that LPS is supposed to fix, and in particular for ICBs, deprivation of liberty in the community, which is the lovely new acronym DOLIC, which is also new to me. I'm not sure I'm a fan, but there we go, deprivation of liberty in the community. And this is dealt with by COP-DOL 11 applications. So again, individuals perhaps new to working with lawyers in an ICB are probably wondering, what does COP-DOL 11 mean? What are all of these COP-DOL 11 cases that we're having to deal with? So COP-DOL 11 is the way in which we deal with an individual who's deprived of their liberty, living in their own home, or supported living, which since the Cheshire West case has led to large numbers of people being in that scenario. As I mentioned at the top, deprivation of liberty is unlawful unless there's specific legal authorisation, and for these people the only way to get that is through the Court of Protection, and the courts developed what they call well, the form is the COP-DOL 11. The case that established it was called REX, or you might also hear the phrase streamlined procedure. After many years of dealing with this, I've decided that it's only streamlined for the court and not us and not the ICB. And what it basically means is it's a front-loaded application so that the ICB would gather all of the evidence required in advance and then put all of that before a judge. And it's streamlined in the sense that the judge should have everything that they need and hopefully deal with it on the papers rather than us having lots of hearings. There are some challenges in gathering the relevant evidence for a COP-DOL 11. So like I said, I'm not sure that streamline is particularly the reality of individuals in an ICB that are dealing with these cases. Why are they important? There is slim potential for legal challenge for people who are deprived of their liberty in the community, which is unlawful on the face of it unless this is authorised by the court. And I really thought when Cheshire West came out that this would be the next PPI and that we would hear advertisements on the radio, you know, has your loved one been deprived of their liberty without authorisation, give us a call. That hasn't really materialised. It could still, you know, there is still that potential, although the limitation period for human rights claims is only a year. irrespective of whether or not we can get sued for it and have to pay damages, it's the right thing to do. It's about protecting people's human rights, and we need to ensure that there's a proper framework in place to make sure that people's rights are being protected. If LPS don't happen, then COPDOL 11s will still very much be front and centre and necessary for authorisation of deprivation of liberty in the community. If it does come in, LPS, COPDOL 11s are still really important at the moment for a couple of reasons. You will have a 1-year transition period to get used to LPS. So if LPS was to come in on the 1st of April next year, if you got an authorisation from the court on the 31st of March, you have that for the full year, and it means that on the 1st of April, an ICB isn't straddling around with all of its still in the community cases, having to get them authorised, and you've got kind of a nice step into it. And also very similar processes and assessments will be required. So the time spent in dealing with COPDOL 11s and getting those processes together is still time well spent, and it'll stand you in good stead for dealing with LPS if and when it comes in. I can see the time. We have lots of experience, I'm sure you'll expect me to say, with dealing with COPDOL 11 applications, training and support for staff having to gather the evidence, and also fixed fees and dealing with them at scale. So if there's anything you want to discuss, then drop us a line, and there we go. Done.
Thanks, Joe. My apologies. We've run a little longer on the presentations than planned, so we have eaten into the Q&A time. I'm conscious people who have other commitments may need to go, so please do feel free. But for our part, I speak for Joanne and Paul as well. We're happy to hang on for a few minutes and answer any questions. If we can stop the recording, please, so that you can